When we look at that picture, we see a lot of things, isn't it? So let's just look around the room where we are sitting now. I think there are a lot of products, isn't it? A lot. So all these are creation of human mind, isn't it? So somebody said, tried to see, no, we cannot sit down, we need a chair, isn't it? How can the chair look like? You think in the mind, then to the end we get the product, which is a chair. But then what are the components when you see a product? When you see a product, what do you think about? What are the components which are embedded in that product? I think you will agree with me that there are some monies which have been used to make the product, isn't it? But also you will agree with me that there are some materials which have been used to create that product. And also there are some utilities which have been used to make any product. And this one, which now I'm going to show, of course the labor is there, which has been used, but this one, most of the times we don't think that there are some intellectual property which is embodied in any product. And this is what I'm going to talk about. So, intellectual property is a forgotten component of the product. You will see the product, as she said, when you see now the icons of the application, we just see the icons, but what is behind those icons? We normally forget about it. And that's the intellectual property which went in that application program. Even in institutions where subject to production, financial management are taught, this component is not taught. You are coming from IFL. Is there in your syllabus something to do with intellectual property? I don't think. But this is the contribution which the developers are giving to the physical product which we see at the end. But that's not a physical product, it's not a tangible, but from the intangible product, which is the IP, then we see the tangible product which we can use and of course make our lives better. So even the developers themselves, they forget that they are putting their intellectual property in those products. That's a bit about it. So we see that historically, intellectual property rights systems were first developed in countries with a strong industrial research and of course development. This goes back to the 16th century, whereby in Greece, people used to take their products to exhibitions. But later on, people didn't want to take, because when I take my product to the exhibitions, somebody will copy it. So issues of intellectual property started so that the one who has designed a product can be protected. But this is, we can see later on, is a very powerful tool for economic development and wealth creation. But it's very unfortunate that in this part of the world, in developing countries, this is not very much embraced. So what is intellectual property? We say it's a creation of the human mind. It's a product of human inventivity or creativity. And it's a result of creation of human mind. So the intellect which we use to create products, this is the intellectual property. Examples, for example, an idea, a computer program or an application, a new plant variety, a method of extracting information from a database, or a product. These are examples of intellectual property. But when we say property, what are the characteristics of any property? We see that a property is possessed by someone and it has got value. Of course, it can be exchanged, and if it's stolen, you can go to the court that somebody stole my property, but also you are free as the owner of the property to use it. But what are the specific characteristics of intellectual property? You see that this intellectual property is related to information, and it could be incorporated into a tangible object, and it can be reproduced in different locations and used by several persons at the same time. So let me give you an example. For example, if you've got a brass band, somebody, a composer, has written a music, isn't it? It's in the form of a noten. So the noten are in front of the players. They can read the noten and play that music. So that noten is not a music, isn't it? But now the noten, which is the IP, has been transformed into a tangible object, which is the music or the song or whatever. But now, if a brass band is playing that music here in Dar es Salaam, and some other people in Nairobi are having the same noten, they can play the same music, isn't it? So it can be reproduced into different locations to the same composer who has written that music. But also several persons can use it at the same time. Of course, two people cannot drive a car at the same time. But now that type of music, I mean, the noting can be played by this brass band at the same time being played by the other brass band. So this is the specific characteristics of intellectual property. Of course, it also involves the other specific characteristics of any property, which, as I said, it has value and so forth and so forth. So what is intellectual property rights? So we say if you have got your property and now you are given legal rights to the owner of the intellectual property, of course by the state, and we say here that there are these rights for intangible creation of the mind. They are corporate assets, but they are recognized by national laws and international treaties. So the international treaties are there to protect the legal rights of the owners of intellectual property. So what does it mean to have intellectual property rights? It means you have the right to use your property, of course, anyway. Any property would have that right, but you have the right to exclude others from using it. And the right to transfer the right to others through licensing agreements and so forth. But the property rights also come with certain obligations. As you will see, suppose you are given a patent, you are given a right for your protection by a patent, but you have some certain obligations also to meet through those rights which you have been given. We are having two major categories of intellectual property rights, namely industrial property rights. These are intangible assets created for advancing technology, industry, and trade. But also we have got copyright and neighboring rights, which are for the advancement of cultural undertakings. So let me talk first of the first category, but of recently there have come another category which they call emerging issues. But this, I'm not going to discuss them here. So industrial property rights, there are a number of them. We have got what they call the patents of invention, utility models, industrial designs, trade and service marks, trade secrets, geographical indications, plant breeding rights, layout designs, indigenous and traditional knowledge. So let me start with the patent of inventions. Of course, maybe many people as software developers, this might not be of very much concern, but in the United States of America, they protect some of the programs by patents. But in most of the rest of the world, they don't protect by patents. But what is a patent? We say it's a legal right given to owner of an invention, innovation, in a specified territory for a period of 20 years. So a patent has got limitations in terms of time, that's the period, and it has got limitations in terms of geographical territories. So if I own a patent in Tanzania, and I have not asked or I have not requested for a patent in Kenya, it means that my patent is only valid in Tanzania. So it involves geographical limitations. So I have to go again to Kenya if I want to protect my invention or innovation. And here by innovation, we mean a solution to a technical problem. But this confers a very high level of exclusive rights to prevent others from using, making, offering for sale or selling the invention. So, but this seems to be a little bit funny. If I've got invented things and I prevent all the others from using it, it means you have, if you want to use it, you have to go to get my permission. And of course, there are some conditions which you have to meet for you to be granted a patent. Novelty, it must be new, it must be non-obvious, and it should be industrial applicable. Utility models are like patents, but these they are referred to as pet patents. They provide protection for models and designs. The term of protection is 10 years. So patent is 20 years, this is 10 years. But again, let me just, what I said, these rights comes with the obligations. For example, if we are to grant you a patent, you have to tell us in details about your invention, so that a person who is skilled in the art, if he follows your description, you should come with the same product as your invention. So this, you are obliged to teach the society about your invention, but you are now protected by the society so that people cannot copy your invention. Industrial design. So this protects only the distinctive appearance of the product. So if you have got a machine, you can get a patent for the workability of that parts of the machine and so forth. But now you design the curve of the machine. So that curve of the machine can be protected by industrial design. But mostly these are used for issues like handicrafts, building materials, textile toys, etc., etc. The period of protection is 10 years. So there you see, I've got example of 2 bottles. I think for my fellow Tanzanian, this bottle here, you can know, it's not written anything, but you can tell what type of bottle is it, isn't it? True. Kilimanjaro water, isn't it? From the shape of the bottle. And this one, I think you can also know it. Right. Yeah, Suhai, isn't it? So from this industrial design, from the shape, of course we know even the Coca-Cola bottles, you can recognize it without even seeing that's written Coca-Cola. So trade and service mark, this is a word, sign, symbol, or number used to identify goods or services. Normally what it does, it differentiates a product from one trader to another. It differentiates Kilimanjaro water, as I said, from Uhai water. So the product is the same, is water, but these trademarks, Uhai, Kilimanjaro, they differentiate that this one is being made by this company and this one is being made by this company. But what is important in the trademark is that it is a kind of assurance of the quality. If you go to some of the people, they go to the shop, they find high water they cannot buy because they believe it's maybe low quality, then he wants to buy Kilimanjaro water, or the other way around. Yeah, but there is also here the trademark. It's not necessary that you register your trademark, but it's very important to register. Because if you need to register your trademark and somebody else produces the same product as yours, you cannot now take him to the court of law because you didn't register. So we cannot say that this is yours. And of course there are some cases. Here in Tanzania, I remember of one case about the trademark which is called POA. Ngano poa, sembe poa, so poa until. Simezisikia jamani? Yeah, and one company, I think issues of intellectual property to be the same, you are safe for a policeman. Yeah, so this company found that it loses the sales. And they said, why are we losing the sales? And when they went out there to the marketplace, they found that there is another poa. And because they registered their mark, they took these people to the court. And the other company which was infringing the trademark was fined around 700 million Tanzanian shillings for infringing the trademark of another company. So it's very important to register, but it's not necessary. I mean, you cannot. It's not only that you are breached, but it's necessary for those reasons which I just given. And this is why now, because I'm talking to the people who are making applications, mostly we know that the applications will be protected by copyright. But also, I think you can protect your application by trademark. Yeah, you can use trademark also to protect your protection. So there's also another form of protection which is called a trade secret. This is the right to keep confidential business information which have got competitive edge or competitive advantage. But this is being protected through civil and criminal laws. There's no registration procedures, no any exclusive rights guaranteed. If somebody comes again with the same product, you cannot take him to the court. But it's difficult to enforce, and it denies the society to understand about the invention, because now you are keeping it as your own secret. So the society will not understand about your invention. And here we put an example of the Coca-Cola formula. So the Coca-Cola formula, nobody knows it. They try to protect it through trade secret. So copyright. This is the second category. We said copyright and neighboring rights. For the copyrights, we have got literary works, artists' works, computer programs, electronic databases. These are protected by copyright, but we have also what they call the neighboring rights. The performers' rights, producers of phonograms or broadcasts. You see, for example, you remember the case of the comedy. The comedy, I think, were in East African television or another TV, whereby they were performing their comedy plays, but the players didn't have a proper agreement with the television broadcasters. The broadcasters were having the copyright for the comedy. So when they left, it was difficult for them to go again and play comedy in another broadcasting television. And then, of course, they changed now the name to comedy. I don't remember the name now. Comedy original. Yeah, and then they left the other comedy. So those are issues of intellectual property rights. So the copyright and the neighboring rights, they protect the original literary and the artist's works. And this is almost automatic. So once you put your work in a fixed, tangible media of expression, then automatically you are protected by the copyright. For example, if you write a book, now the book is out, then you are protected. So if I play a music, I make a CD, so with that CD, automatically I'm protected. But of course, you need to ensure that I'm very much protected. Some of the people, they go and register their copyright works. But it's not necessary that you can go and register your copyright works. So the term of protection, I think the copyright is the one which is having the longest term of protection. First of all, it's to protect you from the time you put your idea or your work in this fixed expression, fixed media of expression. You are protected from that day till the whole life of the author, but plus another 50 years after the death of the author. So for example, Michael Jackson, because he was protected, his music was protected by the copyright when he was alive, but now from when he died, another 50 years, there will be a protection for his works. And of course, his family is going to benefit from that work. But for the corporate bodies, it's going to be 50 years. because now the copyright code cannot die and so forth. So it's only 50 years. So for the copyright, these are being regulated by the Berne Convention for the Protection of Literary and Artistic Works of 1886, whereby we in Tanzania, we acceded to that convention in 1994. And of course, here in Tanzania, copyright issues are being guided by Copyright and Neighboring Rights Act of 1999. And of course, the Copyright Society of Tanzania is the one who is regulating issues of copyright. So for the company registration, these are being registered under the Business Registrations and Licensing Agency. In Tanzania, you can register 4 types of companies. You've got the private companies, the non-private companies, foreign companies, and the parastatal or state-owned companies. So for the private companies, they are normally formed by persons with the prior relationship other than business. So for example, maybe you and your family and some friends, we've got some relationship, then you can form a private company. The membership is minimum of 2, maximum of 50. It cannot exceed 50. Shares are not transferable, and they are supposed to submit annual returns and any other statutory fileable document to the registrar. So this is a private company. So the non-private companies is open-ended, membership minimum of 7, but there's no maximum, there's no restriction for the maximum. It can be as many people as possible. And the conditions for incorporating, you have to have prospectus to state the objectives of the company, the proposed share capital, sources of finance, as an invitation for people to come and buy shares in that company. And of course, a private company can also be a public by changing or amending the articles of association and increasing the minimum number of people to 7. Foreign companies, these are companies incorporated out of Tanzania. So maybe this is a Kenyan company, but it wants to have an office in Tanzania. So these offices will be treated as branches. And for registration procedures, you need to submit the certificate of memorandum of articles of association, loss of location of the registered office in the country of domicile, list of directors of the company, but also you need to have a person who is a resident in this country who are representing the company. The fees here is US dollar 1,100 for registration and 300 for filing. For state-owned companies, these are normally private companies which have more than 50% stake in the government. So the government has got a big share in those companies. So for all companies, if you want to register, there are 3 types of fees which you have to pay: registration fees, filing fees, and stamp duty. So the registration fees, these depend on the nominal share capital. So if you visit the website of BRELA, you can find the fees. I think they range from They range from 50,000 to 300,000, depending on the nominal share capital of the company which is going to be registered. And of course, the filing fee is just 45,000 Tanzanian shillings, and you have to pay stamp duty, 6,000 for the regional memorandum of articles of association, 1,200 for the form, and 5,000 per copy. It depends on how many copies you want to be stamped. So I end up there. I welcome questions and comments.